Good morning, everyone. I'm going to start with a new chapter, Judiciary of NCERT Class 11 Political Science. And this chapter starts with the question, why do we need an independent judiciary? Independent judiciary की ज़रूरत क्यों है? That is because in any society, disputes can arise between individuals, between groups, and between individuals and groups on one side and government on the other. And ज़रूरत फिर ये होती है that those disputes they must be settled by an independent body in accordance with the principle of rule of law. और principle of rule of law का मतलब है कि everyone is equal before law, whether you are poor or rich, powerful or powerless, you belong to a forward caste or backward caste, the same rule of law applies to you. And then herein the role of judiciary comes in, which is to protect rule of law and ensure supremacy of law. फिर अगले सवाल, what is meant by an independent judiciary? कौन से aspects हैं which decides that if any judiciary is independent? And then how constitutions and convention they ensure this independence. So सबसे पहले बात करते हैं, what are the simple aspects of independence of judiciary? The first one is that the other organs of government, which are, if you might be able to recall, that there are three organs of government: legislature, executive, and judiciary. So here, from the perspective of judiciary, legislature and executive both are the organs. So the first principle for that ensure the independence is that those other organs they should not restrain the functioning of judiciary. And restraining here it means किसी तरह का दबाव, किसी तरह का प्रेशर, कोई इंटरफेरेंस वो सब नहीं होनी चाहिए. Then the second principle that those other organs of the government they should not interfere with the decisions of the judiciary, because judiciary का काम है that it looks at the evidences and uh, by comparing those evidences with the convention and laws, with the constitutional provisions, it arrive at a conclusion, at a decision, at a verdict. And those decisions they should be based on the rule of law, they should be based on the constitutional provisions and not on the pressure, not on the interference by other organs of the government. And the third principle is that judges they must be able to perform their function without fear and favor. इसका मतलब है कि no legislator, no politician, no powerful and rich person, no pressure group, no lobby, no one can no one can influence the judges in a negative way, so that they can function without fear of removal or without favor, which means no corruption at all. Then ये सब देखने के बाद it does not imply that independence of the judiciary is the sole the sole prerequisite of the establishment of the constitution. It is not that constitution is merely there to serve the independence of judiciary, nor are people, nor are the other organs of the government. It is just an aspect that, according to constitution, is there and should be there to protect the rights of individual and to resolve disputes according to a principle of rule of law. So here, independence, it does not imply arbitrariness or the absence of accountability. Judges, they are also part of government, and government, all in all, it is accountable to people. The constitution, the constitution itself, and then the institutions such as legislature, executive, judiciary, all such functions, all such mechanisms, rules, by rules, laws, customs, all are there because of people. People are not there because of legislature or executive or judiciary or the constitution. So there is no inverse relationship here. And judiciary, its independence is ensured so that it can function in an effective way. But that does not mean it is not accountable to anyone. Judiciary is accountable, and it is accountable to the democratic structure, the democratic practices of the country, and it is also accountable to the constitution and to the people of country. Then another question comes: how can the independence of the judiciary be provided, protected, and ensured? So there are a number of measures in the constitution which has ensured the independence. First one is the legislature. It is not involved in the process of appointment of judges. So legislature branch of the government, which consists of the legislative bodies such as parliament on the central level. And parliament, it is the group of representatives of people. So in short, parliament is miniaturized version, miniature people. So if those representatives have reached there and sit together to deliberate upon any issue, it seems and it appears that the people, the whole country has arrived to debate and to talk about any issue. So this is version of democracy. This is a new version of rule of law. This is for the time being and in the present circumstances is applicable for countries such as big as India. But my point is those representatives, लोग सारे लोग एक साथ नहीं आ सकते. That's why we send representatives to uh, to debate, to negotiate on our own behalf. And let's coming back to where we started. So this legislative branch, parliament, it is not involved in the process of appointment of judges. Why is that so? Why isn't parliament or the legislature involved in the appointment of judges? It is because parliament is the people itself, and they are diverse variety of diverse sections of people, not only in social or cultural terms. There are other factors that need to be counted, such as on financial terms. They are rich people, very rich people, very financially powerful people. And then there are people from classes such as people from forward caste, and they can be people can be represented by any despots such as those who are practicing discriminatory practices, because it constitution has not provided any avenue, any other criteria about who is going to be appointed, who is going to be elected as a parliamentarian. There are no rigid rules here. Even if you are talking about violence, even if you are talking about gender discrimination or caste discrimination, if people likes you and if people wish for such an election, you are likely to get the coveted seat. So my point is the other aspects or other strata can be there, and there are many pressure lobbies, powerful groups, and there are corporate lobbies as well. There are people who are represented by interests. For example, let's take an elaborate way. ये इसलिए कि ये चीज समझ में आ जाए. Parliament, it is the group of representatives, and representatives are the people, are the elector that represent people, which in short means if they have arrived, it means a whole section which they represent, it has arrived as well. So it's like they are miniatures, or they are voices of people. So in short, it can mean the representation itself mean that if a single person has arrived, he is not a person anymore. He is the voice of a group of people. So all those voices, the voices can be different. Parliament can be called a house of voices and interests. And now it isn't that we are working or we are talking about a black and white situation. There are many gray areas. So what is the black and white situation, or what is the gray or vivid colors that I am talking about? It that let's talk about the exploitation of resources, the exploitation of minerals. And now we know that in order to develop, in order to financially promote the development of the country, we need exploitation of minerals. And those mineral resources that are housed in tribal wealth. So now we are looking at a conflicting situation. At first, they are entrepreneurs, they are industrialists who wants to mine those resources. But by mining, the livelihood and the habitation, the houses of those tribal people, they will be demolished. So here we are looking at two conflicting situations. One is development and the second one is habitat. And both of these voices, they will be represented in the parliament. So here I'll write a corporate lobby, those in the interest of mining those resources, and they will be tribal lobby, those representing the protection of tribal habitat. And then there will be a feminist dimension. And along with that, there will be another, the contrary, the opposite representatives, those who will be representing the patriarchal norms. Then there will be a student lobby, a labor lobby, and all such groups will be housed in all such voices. They will be housed in this lower house or even upper house as well. So coming back to the question, why is parliament, why the houses, Lok Sabha and Rajya Sabha, they are not involved in the appointment of judges? Because the judges themselves, they also belong to the population, they also belong to the same population, the same stock from which the representatives are elected, and they may belong to one of these sections. So here the fear favor dimension, it cannot be ruled out. The possibility of influencing by fear or favor, it is there, and to rule out any such possibility or expectation, it is better that legislature should not be involved in the process as well. They may the judges, they may personally uh, belong to, they may personally want to take the side of feminists or the tribal lobby or the corporate lobby, and in such situation, unka decision, it is going to be influenced. So that is the reason of not involving the legislature, and it is also that party politics would not play a role. Then, in order to be appointed as a judge, a person must have experience as a lawyer or must be well versed in law. And especially for to be appointed as a Supreme Court judge, 10 years of experience is needed. Then the other aspect, the second aspect of independence of judiciary is that they have fixed tenure. So they hold the office till the age of retirement. And it is not that they are free from impeachment or removal process. उनको भी हटाया जा सकता है, but the grounds of removal are strict. They can be remove on the grounds such as proved misbehavior or incapacity. Other than that, they have a fixed tenure, or its removal maybe it is very difficult. It can happen only in exceptional circumstances, and so far we have only one instance of unsuccessful attempt to remove a Supreme Court judge, a High Court judge. Yeah, it was a Supreme Court Justice Ramaswamy. Then the procedure to remove a judge, it is also difficult. We will look into it further. Then the third aspect of independence of judiciary, it is that judiciary is not financially dependent on the executive or the legislature. So what is this financial dependence? Look what happens. India एक country इसको इसका जो पर्सनल या फाइनेंशियल मैनेजमेंट है just assume it to be similar to be financial management of an individual. So जैसे financial management होता है for one individual, that your account will be maintained in the same way the financial statement of government of India also is maintained in the form of budget, which is also known as annual financial statement, and in it there is whole bureau of the incomes and expenditure, same as any individual would want to maintain his account, income and expenditure. Now, to make any expenditure, Lok Sabha, if you are able to recall, that all such financial power to make any changes to it, such as if you want money for to be spent on resources, if you want to give grants to state government, किसी भी तरह की जरूरत है पैसे की, those changes they are accomplished via the money bills. And money bills, it is the prerogative, it is the sole power of Lok Sabha, because Lok Sabha members, the parliamentarians of Lok Sabha lower house, they are directly elected by people. So in a way, the financial management, it is directly accountable to people. That is the one possible reason. Then in order to make the expenditure, Lok Sabha, it has to take the approval of parliament. But the running of judiciary and the salary and benefits of judges, both of them, they are not accounted for. They are directly made from the Consolidated Fund of India, CFI. So in a way, the parliament, or in particular Lok Sabha, it has not been given the power to reduce or increase or to influence the salary, the benefits, and all the financial instrument of the various organs of judiciary, including the judges. So it has been kept out of the ambit of the legislature so that they could not be influenced. So here it is written, the salary and allowance of judges are not subject to approval of the legislature. For approval of legislature, it is necessary क्योंकि पार्लियामेंट लोकसभा को जब भी पैसा चाहिए, it needs to approve by the legislature by presenting budget or annual financial statement. Then the fourth power is the actions and decisions of judges. They are immune from personal criticism. कोई भी legislator, कोई भी parliamentarian, they could not criticize the conduct of judges, not only in the House of Parliament, not only in the parliamentary proceedings, but in the individual capacity as well. Even in media, in front of any news channel, or even in a personal communication, they are immune from such criticism. And if any such abrogation is found out, पता चला judiciary को कि someone has done it, then that person, that guilty, it can be booked under the contempt of court. Then the next power, the next principle for the independence of judiciary, it is that Parliament itself, it cannot discuss the conduct of judges except when judges being removed and the proceeding thereof is carrying out. Other than that, Parliament, the whole parliamentary proceedings, all the sessions of it, they cannot talk about, they cannot discuss the conduct of any judge. This is the power of, this is the mechanism by which independence of judiciary is being ensured. Now let's talk about appointment of judges. Well, I'm going to talk about appointment of judges in the next video. This is all for now. Thank you very much and kindly subscribe the channel.